somewhere in the American West, there exists a place where the law cannot reach you. A zone where any crime, no matter how severe, cannot be prosecuted by any court in the United States. This is not fiction. This is not a conspiracy theory. This is a verified constitutional loophole that legal scholars have confirmed for over 2 decades. Welcome to the Zone of Death, a 50-square-mile corridor inside Yellowstone National Park. A place where the United States government has accidentally created the perfect crime scene. The discovery of this loophole sent shockwaves through American legal academia. And yet, over 20 years later, Congress has done absolutely nothing to fix it. Why? That question alone should terrify you. Today, we pull back the curtain on the most dangerous legal blind spot in American history. The story begins not with criminals, but with the United States Constitution itself. Specifically, with 2 clauses buried deep inside the 6th Amendment. Yellowstone National Park spans 3 states, Wyoming, Montana, and Idaho. The park itself is enormous, over 2 million acres of volcanic terrain. Most of Yellowstone falls inside Wyoming, but a thin sliver crosses into Idaho. That sliver, roughly 50 square miles, is the Zone of Death. On paper, this Idaho corner of Yellowstone looks like any other wilderness area. Dense forests, geothermal springs, remote mountain trails few tourists ever visit. But beneath that scenic surface lies a constitutional time bomb. The entire Zone of Death has 0 permanent residents, 0 citizens who could ever serve on a jury. And that single fact is what makes it legally untouchable. Yellowstone National Park was established by Congress in 1872, making it the world's first national park. But when Congress created the park, the surrounding states were barely formed territories. No one paused to think carefully about jurisdictional boundaries because no one imagined they would ever matter. That oversight, buried for over a century, would eventually become one of the most alarming legal discoveries in modern American history. The 6th Amendment to the United States Constitution guarantees every accused person the right to a jury trial. But that amendment contains 2 very specific requirements most Americans have never noticed. Requirement 1, the trial must occur in the state where the crime was committed. Requirement 2, the jury must be drawn from the district where the crime occurred. Now here's where the trap springs shut. Any crime committed in the Idaho portion of Yellowstone must be tried in the District of Wyoming. That part is straightforward. The entire Yellowstone Park falls under Wyoming's federal judicial district. But the 6th Amendment also demands the jury must come specifically from the state and district of the crime. The crime happened in Idaho. The jury must include Idaho residents from that specific district. But 0 people live in that Idaho portion of Yellowstone. There are no residents to draw from. No jury. No trial. No conviction. No justice. A competent defense attorney could walk any defendant completely free, citing constitutional grounds. This is not a technicality. This is a fundamental right that no court can legally override. The Constitution itself becomes the shield protecting anyone who acts within the Zone of Death. It is, by every legal definition, the perfect structural loophole. The man who first uncovered this loophole was not a detective, not a criminal, but a law professor. His name is Brian Kalt, a legal scholar at Michigan State University College of Law. In 2004, Kalt published a groundbreaking law review article titled The Perfect Crime. Kalt spent years researching the constitutional implications of Yellowstone's unique cross-state geography. What he found disturbed him deeply enough that he tried to warn Congress before publishing. Kalt wrote directly to members of Congress, explaining the loophole and urging legislative action. Congress received the warning. Congress understood the warning. Congress did nothing. Only after years of silence did Kalt finally publish his findings for the academic world to see. The article detonated like a legal bomb across universities and law schools nationwide. Other legal scholars confirmed Cult's analysis: the loophole was real, verifiable, and frightening. And yet, as of today, the zone of death still exists, unchanged, unpatched, and wide open. The question haunting every legal scholar is simple: why hasn't Congress acted? In 2005, just 1 year after Cult's article appeared, the loophole was actually tested in a real federal case. A man named Clarence Bevins was apprehended inside Yellowstone National Park after an armed confrontation. Bevins had allegedly threatened a park ranger and was charged with serious federal offenses. His defense attorney, fully aware of Cult's published research, raised the constitutional loophole argument. The argument was bold, unprecedented, and terrifyingly logical. The federal court, however, chose to sidestep the argument rather than directly confront it. Bevins was ultimately found responsible on other charges, but the constitutional question was never fully resolved. Critics argued the court had dodged the most dangerous question in American constitutional law. The loophole remained open. The precedent remained unset. The danger remained real. Legal scholars published follow-up articles, all reaching the same chilling conclusion. Until Congress acts, the zone of death is an open invitation for the most extreme offenses imaginable. So why hasn't Congress simply fixed the loophole with a short piece of legislation? Some legal experts believe the answer is pure institutional inertia. No lawmaker sees political gain in fixing it. After all, what senator campaigns on fixing an obscure constitutional quirk in a wilderness no one visits? Others point to a darker theory, that powerful interests benefit from legal gray zones in protected federal lands. Poachers, smugglers, those who operate in the shadows of America's most remote landscapes. While these theories remain unproven, the silence from Washington grows louder every passing year. The fix itself would be remarkably simple: one bill, one vote, a single paragraph of new law. Brian Cult himself drafted proposed legislative language to seal the loophole permanently. Congress received that draft. Congress filed it away. Congress moved on. And so the zone of death remains, a living monument to American legislative paralysis. The implications of the zone of death extend far beyond one park in Wyoming. Legal experts warn that similar jurisdictional gaps may exist in other multi-state federal territories across America. The Yellowstone loophole reveals a fundamental truth about how American law was assembled, hastily and imperfectly. Some legal scholars have used the zone of death as a classroom thought experiment for law students. The thought experiment reveals uncomfortable truths about constitutional absolutism in the modern world. What happens when a document written in 1791 collides with a geography its authors never imagined? The zone of death is the answer, frozen in the wilderness of Idaho, waiting for the day someone decides to use it. As of today, no confirmed case has fully exploited the zone of death to achieve total legal immunity. But the loophole is open. The wilderness is vast. And the law, in this one forgotten corner of America, simply does not exist.